Bhattacharya, Sri Rabilal Maitra, Milan Sarkar, Arindam Bhattacharya, my dear friend Shomajit Raha, and all the office bearers of ILU, not only here in Bengal, but my dear friends from Kerala and Telangana, and all the other dear friends here who are present. I consider it a great privilege and an honor to be invited to deliver this keynote address before this very enlightened gathering of lawyers who've come in from all over the country. After listening to the galaxy of legal luminaries this morning, I hope I'll be able to meet your expectations about the topic that I have chosen to address you on, namely judiciary and the democracy. Since history has to teach us a lot, and it is possible that there are younger members in the audience who may not be aware of one particular decision that was rendered by the Supreme Court and which is very relevant for today's topic, I wish to begin with that. Something remarkable happened on 11th November 1975 in the Supreme Court of India. 5 judges constituting a constitution bench delivered their judgments in the case of Indira Nehru Gandhi versus Raj Narayan. The court was unanimous that the 39th Amendment to the Constitution of India, which insulated the elections to the office of the President, the Vice President, the Prime Minister, and the Speaker of the Lok Sabha, which challenged these elections from being, which immunized these elections from being challenged in the courts. These judges held the said amendment to be violative of the basic structure of the Constitution. In fact, this was the first major case in which the basic structure doctrine explained in the Keshavananda Bharati case was applied. I must urge legal scholars to carefully study this judgment, and particularly the opinion of Justice H.R. Khanna, because it's one instance of the judge explaining his own opinion which tilted the balance in the Keshavananda Bharati case. If you recollect, it's a majority of 7:6, with Justice Khanna being the tilting vote. And in this judgment, in Indira Gandhi versus Raj Narayan, he explains his own judgment in Keshavananda Bharati. None of the judges had any doubt that the independence of the judiciary, the equality clause in Article 40, and the notion of free and fair elections constituted basic features of the Constitution. They viewed the 39th Amendment as a declaratory judgment by the legislature, and therefore an usurpation by the Parliament of the judicial powers when it came to elections to a select few public offices. I must also point out here that what the 39th Amendment did was to introduce Article 329 capital A in the Constitution of India, and clause 4 of that article held that elections to these public offices would be insulated from judicial challenge. Clause 5 stated that an appeal against any order of the court pending before the commencement of this constitutional amendment shall be disposed of in conformity with Article 4, which means that all the judgments, and in particular the judgment in Mrs. Gandhi's case, election case, would get nullified. The background to this judgment, of course, was the challenge to her election mounted by Raj Narayan in the Allahabad High Court. On 12th June 1975, Justice Jagmohan Lal Sinha invalidated that election on a variety of grounds. It will be recalled that in the 1971 general elections, the Congress had a thumping majority of 372 seats in Parliament. It was a brute majority. The challenge was that Mrs. Gandhi had far in excess of the limits spent on her campaign, that she misused government office, that one of her personal secretaries, Yashpal Kapoor, who also happened to be a public servant, was actually campaigning for her, addressing meetings in Raebareli constituency, from where she got elected. Justice Sinha, after invalidating her election, suspended the judgment for a period of 20 days. There's another story to that suspension of judgment, which I don't think we should be engaged with at this stage. It will form a very interesting anecdote for somebody who's done deeper research into that very critical point after pronouncement of the judgment about the lawyer who went before the judge and got a stay of that judgment. That lawyer went on to become the Chief Justice of India. He stayed the judgment for 20 days, and naturally Mrs. Gandhi appealed to the Supreme Court. The Supreme Court was on vacation. The best legal brain in the country, Mr. Nani Palkhiwala, was engaged to appear for Mrs. Gandhi. The judge in the vacation bench of the Supreme Court hearing the stay application was none other than Justice Krishna Iyer. Mr. Palkhiwala argued for a complete stay of the judgment. Arguments were heard on 23rd June 1975, and a 23-page interim order was passed on 24th June 1975. Justice Krishna Iyer declined to grant a complete stay, but granted a conditional stay. Justice Krishna Iyer said in his interim order that Mrs. Gandhi could continue being the Prime Minister of India, but she would not be entitled to vote in Parliament. Historians believe, and many political scientists believe, that Mrs. Gandhi was so taken aback that there was not a complete stay of the judgment that this hastened the decision to declare an emergency. Her closest advisors included at that point in time, because we are speaking in West Bengal, Sri Siddharth Shankar Rai, later to who was already earlier a chief minister of this state, and Rajni Kothari. I'm sure when biographies are written about these gentlemen, I don't know if they've already been written, we'll have other versions of these stories. But the proclamation of emergency under Article 352 of the Constitution, which itself was very controversial in the manner in which they got the presidential assent for that declaration. It was announced at 6 a.m. on 26 June 1975 over All India Radio, and that is when people knew that there was an emergency in this country. Beginning midnight of the intervening midnight of 25th and 26th June 1975, important leaders of political parties in opposition to the Congress were all picked up and detained under the Maintenance of Internal Security Act. I'm sure the younger lawyers must have heard this word MISA spoken about by their elders. This included Sri Jayaprakash Narayan, it included Sri Morarji Desai and a host of other political leaders, some who managed to get tipped off and managed to escape, which included Mr. George Fernandez, and one other very interesting personality who was very much around and vibrant in today's politics, Mr. Subramanian Swamy. So this was the darkest hour in India's legal political history. Justice Krishna Iyer expected that the case would be listed at an early date for a final hearing. So he fixed 11th August 1975 as the date of final hearing of Mrs. Gandhi's election appeal in the Supreme Court. On 10th August 1975, this amendment was passed in Parliament, the 39th Amendment. Very reminiscent, and that's how history repeats itself. With most of the opposition out of the Parliament, there was no resistance to passing this very important amendment. Why it's important to go back to history is we should not pretend today that all this is happening for the first time. It's happened before, and if we are not alert, it will continue to happen. Which is why it is very important for us to discuss this topic of judiciary and democracy. Like I told you, this amendment did two things. One, it insulated the challenge to elections to all these offices, President, Vice President, Prime Minister, Speaker of Lok Sabha, from challenge in the judiciary. But also importantly, it nullified the existing proceedings in court. It says notwithstanding any judgment. So which meant the appeal, and the sub-article 5 of Article 329A in fact said, if there's any appeal pending, it has to be decided in accordance with sub-article 4. So which really meant the appeal would get nullified. So naturally, when the case was called out on 11th August, it could not proceed on that date. Mr. Rajnarayan, of course, mounted a challenge to the constitutional validity of this 39th Amendment on the one among many grounds that it violated the basic structure of the Constitution. Now, what the Supreme Court did, and this composition of the bench is also very interesting. This bench comprised Chief Justice A.N. Rai. It comprised Justice M.H. Beg, who was to succeed Justice Rai at that time, although Justice Beg did not know he was going to succeed Justice Rai as Chief Justice of India. It comprised Justice K.K. Mathew, Justice H.R. Khanna, and Justice Y.V. Chandrachud. Unanimously, this bench decided a few things. One, like I already told you, they struck down the constitutional amendment as being violating the basic structure. They held this sub-article 4 to be a declaratory judgment by the legislature. And in the words of Justice Rai, judicial power in the sense of the judicial power of the state is vested in the judiciary. Similarly, the executive and legislature are vested with powers in their spheres. Judicial power has lain in the hands of the judiciary prior to the Constitution and also since the Constitution. It is not the intention that the powers of the judiciary should be passed on to or be shared by the executive or the legislature, or that the powers of the legislature and the executive should pass on to or be shared with the judiciary. So what he is expostulating here is the doctrine of separation of powers. And he goes on to observe that clause 4 of Article 329A in the present case, in validating the election, has passed a declaratory judgment and not a law. The judgment, the legislative judgment in clause 4 is an exercise of judicial power. The constitutional power can exercise judicial power, but it has to apply law. The validation of the election is not by applying legal norms, nor can it be said that the validation of the election in clause 4 is by norms set up by the constitutional power. And he also holds that clause 5, which requires the courts to now decide these appeals in accordance with clause 4, cannot also be sustained in law. So one of the pillars on which the conclusion rests is that the independence of the judiciary is part of the basic structure of the Constitution, and that this amendment directly undermines the independence of the judiciary. So far, so good. Along with Article 329A, which was introduced in the Constitution, that Parliament, denuded of all the opposition, who were all in jail, passed two other amendments to the Representation of the People Act. These amendments sought to remove the very basis of the challenge to Mrs. Gandhi's election. One amendment removed the restriction on election expenses by making an artificial distinction between expenses incurred by the candidate and expenses incurred for the candidate by the party, and said as long as the candidate does not exceed personally the expenses, merely because the party has spent money for you, it will not be counted. So this basically meant that one ground went. Second, it said that the arrangement of facilities for the election meetings by the government will not be counted as election expenditure. So what these two amendments to the Representation of People Act did was to completely nullify the very grounds of challenge to the election petition, and therefore removed the very basis of Justice Jagmohan Lal Sinha's judgment. These amendments were made retrospective. This should have shocked the judicial conscience of these 5 judges, which included Justice H.R. Khanna. Strangely, it did not. They upheld the validity of these 2 amendments, despite these amendments being retrospective, and they set aside the judgment of Justice Jagmohan Lal Sinha. I think historians now present in the audience should remind themselves that this was the very court, this was the same court which on the one hand was upholding independence of judiciary as a basic structure of the Constitution, and this was the very court which was validating an obviously illegal election of Mrs. Gandhi. I very often think of these what-if moments in India's legal and political history. What if these 5 enlightened judges had in fact upheld Justice Jagmohan Lal Sinha's judgment? What if they had held Mrs. Gandhi's election to be null and void? What if? And that will be a big what if. So what was the court actually doing? On the one hand, it was asserting its own independence, saying that its essential functions cannot be trammeled by the other branches, namely the executive and the legislature. But at the same time, it declined to apply the basic structure doctrine to these two statutory amendments. And none other than Justice Khanna was saying this, that we cannot afford to apply the basic structure doctrine, and this is his reasoning. Basic structures or basic features are indefinable. The legislative entries are the fields of legislation. The pith and substance doctrine has been applied in order to find out legislative competency and eliminate encroachment of legislative entries. If the theory of basic structure or basic features will be applied to legislative measures, it will denude Parliament and state legislature of the power of legislation and deprive them of laying down legislative policies. This will be an encroachment on the separation of powers. So by a legal technical device of keeping the respective functions in tight silos, these two retrospective amendments to the Representation of the People Act were upheld. Actually, in pith and substance, what they were doing is nullifying a judgment delivered by a court. And this should have been very plain for everyone to see what a colorable device this was to overcome a negative judgment. But that's where it is. They recognize that all these amendments have retrospective operation, and therefore the very basis of nullifying the election of Mrs. Gandhi was set aside, which meant she could continue as Prime Minister in Parliament, exercising all powers. And this judgment was delivered within less than 4 months after Justice Jagmohan Lal Sinha's judgment. The signal now to the executive was very different. Once the Supreme Court of India had upheld the election of Mrs. Gandhi, there was no stopping her. So the emergency continued till March 1977, when announcement was made about general elections. And in the meanwhile, the Supreme Court of India delivered 2 more judgments, which again form part of the dark history of the emergency and dark history of the judiciary itself. On 28th April 1976, the judgment in ADM Jabalpur, Assistant District Magistrate, Additional District Magistrate Jabalpur, Mr. Shivkant Shukla, was delivered. Basically, what this judgment did was to legitimize the taking away of any remedy before constitutional courts for violation of fundamental rights. This court, in a majority of 4:1, much has been spoken of the very brave, courageous dissent of Justice H.R. Khanna. The majority comprised 2 future Chief Justices of India, Justice Y.V. Chandrachud and Justice P.N. Bhagwati, both of whom wrote separate opinions upholding the MISA and upholding the negation of the right to a constitutional remedy for violation of fundamental right. This court, by majority 4:1, ruled that once there was a presidential order under Article 359 suspending the enforcement of fundamental rights to life and liberty guaranteed by Article 21, a person who is deprived of his liberty by detention order, even though it was passed mala fide, could not approach the constitutional courts for redress. A third judgment, which is less talked about, but which is even more, I would say, or perhaps as disturbing as the other 2 judgments, is the one delivered on 25th January 1977, less than 2 months before the elections were announced. This judgment goes by the cause title of Union of India versus Bhanudas. This judgment, by a 3-judge bench, which again comprised Justice N. Rai, Justice M.H. Beg and Justice Jaswant Singh, held that presidential orders suspending enforcement of fundamental rights impose blanket bans on any and every judicial inquiry and investigation into the validity of an order depriving a person of his personal liberty. This 3-judge bench held that the court could not even order that facilities be provided to a detainee to be taken from the place of detention to his home, in custody, or to an examination hall for writing exams, or even for a special medical treatment under a doctor of his choice, or for any other facility, because that would be enforcing the fundamental right through the aid of the court. So this was the strict interpretation placed by the Supreme Court of India on these basic needs. Justice Beg weighed in saying, and I'm quoting him, "Speaking for myself, I'm inclined to suspect that a number of allegations made on behalf of the detainees have the oblique motive of partisan vilification or political propaganda for which courts are not proper places," unquote. Thus, a seemingly independent judiciary completely supported the emergency. It took the Supreme Court over 4 decades to overrule ADM Jabalpur. In Justice K. Puttaswamy, the first of the 2 judgments, the privacy judgment, delivered in August 2017, Justice Y.V. Chandrachud's son, writing the judgment, said that the judgment in ADM Jabalpur was seriously flawed, and he went on to observe, when histories of nations are written, certain judgments should be confined to the archives, as they should never ever have been written. Although he was speaking of ADM Jabalpur, I think the other 2 judgments, the Indira Gandhi versus Rajnarayan, at least the portion where they upheld the election of Mrs. Gandhi, and the Bhanudas judgment, are equally disturbing precedents, particularly for democracy. The above 3 decisions tell us something significant about the nature and character of our judiciary, and generally about the role of the judiciary in a constitutional democracy. Facially, it appears that the first decision, that is the Rajnarayan, Indira Gandhi versus Rajnarayan decision, has the following takeaways. 1. The assertion of the basic structure doctrine that limited the power of Parliament. 2. The assertion of the independence of the judiciary flowing from the doctrine of separation of powers and the concomitant doctrine of checks and balances. 3. Upholding the importance of the notion of free and fair elections as essential to a democracy governed by the rule of law. This comes in the opinion of Justice Matthew. I forgot to mention that. And 4, and this is the disturbing part, deferring to the will of the majority in restoring the election of a sitting Prime Minister. What certainly weighed with the Constitution bench in doing this was the fact that she had a popular mandate, 352 seats in Parliament. The Prime Minister under whom we had won a war against Pakistan, given freedom to Bangladesh. This was the prevailing atmosphere at that time, and judges were responding to that popular will in restoring the validity of her election. When, however, one delves deeper, a more complex scenario emerges. It appears that the rule of law was itself used to legitimize an illegal election. One can very well imagine how the course of political history may have been different if the invalidation of that election had been upheld. A powerful executive, backed by a brute majority in Parliament, was able to persuade the judiciary to adopt a hands-off approach when it came to suspending fundamental rights in the name of an internal emergency. The latter 2 decisions, that is the ADM Jabalpur and the Bhanudas decision, coming within 18 months after the Rajnarayan judgment, makes it difficult to believe that the Supreme Court did not foresee the consequence of its decision by which it restored the election of the Prime Minister. It's very well possible that had they not restored her election, had they not validated her election and set aside the judgment of Justice Jagmohan Sinha, the emergency may have ended earlier. It's quite possible. This indeed was an important turning point in the political and legal history of the country. There are many such what-if moments, and let me see if I can mention some of them during the course of this talk. What happened immediately after the emergency? We know now that Mrs. Gandhi lost the elections. It was a rout in 1977. There was a motley group of parties that came to power. It is very important to note here and in this hall that the group that opposed her, led by Shri Jayaprakash Narayan, had the complete backing of the Bharatiya Janata and the RSS. They were very much supportive of coming together to defeat Mrs. Gandhi. And Shri Jayaprakash Narayan is attributed to this quote. I'm sure the senior members here can correct me if I'm wrong. If he said as RSS is fascist, then I'm also fascist. Now, taking a cue from this, the Communist Party of India, I'm not talking of CPIM, I'm talking of CPI, decided to support the emergency. We should be alive and aware of what politics is. All right? My enemy's enemy is my friend. Simple political equations. So we had Jayaprakash Narayan socialites, the Lohiites, the Janasanghis, and the CPI all coming together saying we have to unite to defeat this brute force sitting in parliament. Short-term gains, short-sightedness. Now, of course, in hindsight, we can say how disastrous that was. It took the CPI to regret this move so many years. It is in 2015, I think Gurdas Das Gupta gave an interview saying we made a terrible mistake in supporting the emergency. But that is history for you. Those are the facts, undeniable facts. So this did not last. There was infighting, there was jostling for power. There was Charan Singh wanted to be displaced by Jagjeevan Ram. Charan Singh wanting to displace Morarji Desai. So it did not last. As a result, when this coalition fell apart, Mrs. Gandhi came back with an even stronger mandate in 1980. In this period, between 1977 and 1980, something happened in the judiciary. We had the decision in Husainara Khatun. It was a launch of public interest litigation jurisdiction. Very often people wonder why was it that PIL started in these years between 1977 and 1980. One answer is there was a weak executive, not able to command any meaningful majority in parliament, and a need for the judiciary to step in and reinvent itself after having supported the emergency. I would consider PIL as a jurisdiction of atonement by the Supreme Court. It wanted to reach out to the people and tell the people that we are still relevant as an institution. We care for the poor, we care for the underprivileged, and that's how PIL actually started. So the two major engines for PIL were the two judges with a socialist outlook, known socialist outlook, Justice Krishna and Justice P.N. Bhagwati. Justice Krishna was there in the court only till 1980, but played a very active role in promoting PIL. Both these judges had formed part of a committee that was set up in 1977 itself by the new dispensation on legal aid. And in that report on legal aid, which was authored by these two judges, there is a whole chapter on public interest litigation. The inspiration being what was happening in the United States of America. Justice Bhagwati, for those who may not be aware, as a judge of the Gujarat High Court, had visited the US way back in 1971 and had learnt about public interest litigation in that country. Of course, that's another whole topic by itself. While the origins of PIL was concerned with the judiciary reaching out to the underprivileged, very soon it witnessed the Supreme Court take up issues of public accountability involving corruption of public servants and executive apathy in the field of environmental protection. The 1990s, which again saw weak coalition governments, also witnessed the Supreme Court use to full measure its vantage position of an independent constitutional organ, insulated from interference by the executive and the legislature, and armed with the power of judicial review over the actions of both branches. This was also a period of transition where there was no certainty of a strong majoritarian government at the center. It was an era of coalitions. In contrast with the first judge's case, S.P. Gupta, 1982, where judiciary conceded executive supremacy in the matter of judicial appointments, the Supreme Court from 1993 onwards, from the second judge's case onwards, Scora, reread the word consultation in Article 124 as concurrence, thus ushering in a system of judicial collegiums having the last word on judicial appointments, both to the high courts and the Supreme Court. In another sphere, in the S.R. Bommai judgment, the Supreme Court stepped in to make it very difficult for strong executive governments to dismiss state governments and order president's rule. They devised a new procedure under which such a decision had to be tabled on the floor of the parliament and within a certain time. It is an empirical fact that after the S.R. Bommai judgment, every attempt at imposing a president's rule has met with a successful challenge and therefore a failure on the part of the executive government to continue imposing president's rule. So one salutary effect of the SR Mumbai judgment is stopping the misuse of Article 356 of the Constitution. In yet another sphere, the Supreme Court also had the last validity on the last word on the validity of constitutional amendments. Here I am talking of the 52nd amendment to the Constitution, which brought in the 10th schedule to stop the malaise of defections en masse from one party to the other. And we all know how that has completely been defeated in the recent past. So the judgment in Kihoto Holahan again tested this constitutional amendment on the anvil of the basic structure of the Constitution, and to the extent it insulated the Speaker's decisions from judicial review, it struck it down and said the Speaker's decision on anti-defection issues would be judicially reviewable. When it looked at the constitutional amendments that brought in the administrative tribunals, it again interfered and introduced an additional tier of judicial review in the High Courts under Article 226 of the Constitution against decisions of the administrative tribunals. I am referring to the judgment in Chandrakumar. Even terms and conditions of service of the judiciary were now set down through a public interest litigation brought in the Supreme Court by the All India Judges Association. Judicial review was asserted over purely executive functions, for instance, the power to grant pardon. In Kehar Singh, the decision of the President not to grant pardon was judicially reviewed by correcting the procedure to be adopted for examining such petitions for grant of pardon. In Jagadambika Pal, and this is a 1993 decision, the Supreme Court actually set out a timetable for conducting a floor test on the floor of the Legislative Assembly in Uttar Pradesh. What I'm trying to say is you had a judiciary which was now entering into other domains reserved for the other branches, namely the executive and the legislature, and all of this by using Article 142 of the Constitution for doing complete justice. And it also used its contempt powers for enforcing obedience. Suddenly it appeared that the judiciary was everywhere and anywhere and all the time. While a positive take of the government of the above developments could be seen as judiciary's attempts at deepening democracy, it was being viewed by skeptics as judicial legislation and even rewriting the provisions of both the Constitution and the laws. But from a jurisprudential perspective, there are good reasons why these changes took place, particularly when today one sees a complete change in the attitude of judiciary to very many of these same issues. In order to examine this, we need to understand certain phenomena. First is the phenomenon of judicial independence. While we speak very positively of judicial independence, saying how it is important to insulate judges from interference by other branches, the legislature and the executive, and that this would be a proper check on excesses, one does not look at the structure of the judicial system as a whole. We have to look at appointments, we have to look at transfers, we have to look at disciplinary proceedings, career patterns, not just of High Court judges and the Supreme Court judges, but also of judges in the district courts and courts below the district courts. That entire institution of the judiciary should be looked at if we talk of independence of the judiciary. It is important to remember that although we may insulate the judiciary from interference from other branches, judicial intervention in the political process requires not only an independent and powerful judiciary, but also judges who are willing to intervene. I might give you a completely insulated institution, but sitting in that institution, I must be in a frame of mind where I will want to interfere. So I could be sitting in an insulated institution and still be unwilling to interfere. Judicial independence is not a value in itself, but a means towards achieving judicial impartiality. At the same time, judicial independence cannot become a bar to effective evaluation of the work that judges do. All power must be checked, and the judiciary is no exception. When the Supreme Court expanded judicial power in the manner that I described, what it was actually doing is what legal scholars term as judicialization of politics. The tendency of courts to play a more prominent role in issues governing the country as a whole, leading to the expansion of judicial power, has been termed by scholars as the judicialization of politics. Also, we find that in purely administrative functions, we have brought in norms of judicial functioning, the requirement of compliance with the principles of natural justice, hearing before taking a decision, giving reasons for the decision. These are all aspects of judicial functioning which has entered through administrative law development into the field of decision making by government. How the judiciary enforces accountability in other branches can be understood as both enforcing horizontal accountability, namely that you don't allow other branches to interfere with judicial functioning, and vertical accountability, namely we protect the citizen against the power of the state. The Constitution itself should be read as a document placing limits on the power of the state, and the state in the broader notion, including all three branches, namely the executive, legislature, and the judiciary. A third aspect of accountability is what scholars call as diagonal accountability, where we draw on international doctrines, international principles to develop the law in our country and to offer greater protections. So, for instance, we would draw on international treaties ratified by India to offer greater protection. One instance is the Vishaka judgment, where in the area of sexual harassment in the workplace, we drew on the International Convention of Discrimination Against Women, CEDAW, to frame a set of guidelines which became the law under Article 142 of the Constitution till a statute was passed almost 2 decades after the judgment. So, there is also what is called diagonal accountability, which is enforced by the Supreme Court. I also want to mention that this assertion of judicial power by the court and entering areas which were seen as exclusive silos, whether it's of the legislature, a speaker's decision, or of the executive, of a governor's decision to invite someone to form government, all of these have been subject to judicial review. What it then meant was that there was visible tension between the three branches, where there was a perception that the judiciary was overstepping its limits. It also brought to forth the tension between democracy and the rule of law itself. And here I want to dwell just a bit on what we understand by rule of law. There are two notions of rule of law. One is a narrow, formal, instrumental understanding. Politicians can transfer a decentralized, independent judiciary into a political weapon against their adversaries. There are three ways in which politicians like to judicialize politics. One, where the accountability of politicians is limited, then the probability that politics becomes judicialized increases. Let me take the example of the Association for Democratic Reforms case. If you remember, it is through a judgment of the Supreme Court that it has become mandatory for a candidate in an election to file an affidavit disclosing his involvement in criminal cases and to disclose the wealth that he owns. This came through a judgment of the Supreme Court, increasing the accountability of politicians. When politicians turn electoral victories into exonerative devices, Parliament could become irrelevant, and then political confrontation is transferred to the courts. There's another scenario where the opposition believes that it cannot win elections electorally. Then it takes the incumbent government to the court, questioning its policies and decisions or inaction. If you look back at what happened in the first two UPA regimes, you will find that the court was engaged constantly in issues of public accountability, of corruption. We had the coal scam, we had the 2G scam, and earlier in Bihar we had that fodder scam. So opposition was using the courts to bring accountability and answerability of incumbent governments. A third variation of use of an independent judiciary is by the government itself. The government can manipulate judicial activism to consolidate its power and further neutralize the opposition. You find that there is a PIL challenging a particular issue. Let's say PM Cares Fund. Right? It's one thing to say I disagree with your arguments. The other is to write a whole judgment justifying the PM Cares Fund. So when you go to the court questioning executive authority, you must be prepared that the judiciary will not only negative your arguments but actually provide a full justification for the move. So governments will welcome this kind of a response from the judiciary, where its own actions can be legitimized. We find this being played out in the demonetization challenge as well, which was taken up many years after the demonetization happened. History tells us that this use of independent judiciary by properly elected governments can result in authoritarianism and dictatorships. Nazi Germany was the perfect example of how politicians could use the rule of law against democracy. Rule of law does not necessarily protect democratic political rights. It only ensures that because laws are generally the consequences of actions that can be predicted, and individuals may enjoy greater security from arbitrary sanctions. But the rule of law can still be the rule of bad law as long as the government remains within the limits of a hierarchically ordered and logically consistent system. This is what happened with Article 370. They used the law, they used the procedures, they rushed in through a constitutional amendment, and then 4 years later presented the court with a fait accompli. So using the rule of law itself and the procedures of the law to legitimize what is facially and substantively a non-democratic move. The non-democratic legal system based on the denial of human rights, on extensive poverty, on racial segregation, sexual inequalities and religious persecution may in principle conform to the requirements of the rule of law better than any other legal system. German judiciary, and I don't know how many of you have seen this film called Judgment in Nuremberg, and it's a must watch for lawyers who have not already watched it. It's available on YouTube and you can go and see it. German judiciary played a decisive role in the collapse of German democracy in the 1930s. Although the judiciary was insulated from control by the other branches, it was not a neutral institution. It repressed the left, it tolerated an extreme right, political extreme right, which became increasingly subversive and violent. Again, students of history will recall that the Nazi party used what are called brown shirts. Not the official police or the official military, but these brown shirt cadres to bring about a severely repressive regime directed at Jews, at communists and others whom they perceived as being challenging the establishment. The Nazi access to power used and manipulated democratic means while respecting the rule of law. Politicians and courts therefore subverted democracy by legal means. In fact, the judgment at Nuremberg involves a case where 4 of the judges who served during the Nazi regime were themselves on trial for committing crimes against humanity, because those judgments delivered by them were enforcing the rule of law during the Nazi regime. That rule of law meant segregation laws, treating Jews as non-citizens, subjecting them to humiliation, depriving them of their property, of their livelihood, pushing them to ghettos, all of this done in the name of the rule of law. The second instance where the rule of law itself is used is the Republic of Chile under Allende. He had come to power through democratic means, but the judiciary was still a very conservative body, and the judges there did not agree with the politics of Allende. And so when there was a military coup which ousted him in 1973, and again this was with the support of the United States of America, when General Pinochet came to power, the judiciary at that time welcomed General Pinochet, and the Chief Justice of the Supreme Court in Chile declared to General Pinochet, "I put the judiciary in your hands." So Pinochet had no difficulty in declaring that the new regime will respect judicial power. On its part, the judiciary never questioned the military legality or tried to prevent violation of human rights. So there was actually a collaboration between a repressive executive authority and the judiciary. When the rule of law is used to usher in dictatorships, an authoritarian government can deflect judicial oversight by insisting that the application of emergency powers is an exclusive political prerogative of the executive. They simply dress it up as a political act and advocate judicial abstinence, thereby legitimizing executive excesses. I want you to apply what I'm trying to say to the current scenario, and you will find many answers to why we are where we are. While we discuss the concepts of rule of law, separation of powers, checks and balances, we must also talk of judicial accountability. We've had an unsatisfactory system of self-correction thus far. 2 impeachment attempts have met with failure, unconnected with the merits of the case. Attempts at bringing in law to regulate the conduct of judges has been stillborn. The question still remains, who will judge the judges? When we look back at judicial history in the recent past, the role of our judiciary in bringing about regime changes, both at the center and the states in the past decade, will have to come in for critical scrutiny. In the run-up to the 2014 general elections, which certainly was a watershed one, several issues of public accountability of the other branches engaged the attention of the Supreme Court. 2G scam is one I've mentioned, the Skoll scam or the other, and if you remember, the Supreme Court fast-tracked the trial in those cases. How far the verdicts of the court in some of these crucial cases shaped public perception against the incumbent government at the center may need to be examined not just by law researchers but by political scientists as well. Since 2014, with the present dispensation commanding a sizable majority in Parliament and improving its strength in the 2019 elections, the emergence and entrenchment of what experts in the field of law and political science term as populist regime is apparent. Populist movements, and these are increasingly visible in the world over, whether it's in Europe or Latin America or even Asia, view their success at the hustings as a mandate to bring in changes to the legal system and to the electoral processes. Now you have, therefore, people in authority and power taking pot shots not only at the judiciary but of the notion of the basic structure of the Constitution, of whether we should rewrite the Constitution itself, and advocating for one nation, one election. So it's very natural for populist regimes backed by a resounding electoral mandate to seek to bring about these changes. How courts respond to these calls challenging these changes determines the future course of democracy and politics. When viewed from this perspective, it appears that on the major issues and concerns that have emerged in the past 9 years, the judiciary has by and large adopted either a wait and watch approach or worse still, a non-confrontational approach, thus rendering the challenges futile. The delays in dealing with the challenges to demonetization, abolition of Article 370, introduction of the system of electoral bonds, all of which have a bearing on electoral politics, make it apparent that the judiciary as a whole is not prepared to view these changes as anti-democratic. Its response to the protests both by farmers and those at Shaheen Bagh and elsewhere against the amendments to the Citizenship Act, to the internet shutdown in Kashmir, in the purchase of the Rafale defense aircraft, the questioning of the changes to the Central Vista in Delhi, the challenge to the draconian Prevention of Money Laundering Act, and even the Ayodhya verdict appears to suggest that the judiciary has delivered just what the ruling establishment might have hoped for and even more. Likewise, the judiciary turning a mute spectator to demolition of homes of protesters and minorities using bulldozers with no modicum of due process, the increased instances of hate crimes with the violators acting with total impunity, even while those very issues are pending consideration in the court, are matters of concern. Even when there is a subversion of an electoral verdict by engineering defections on a large scale, making a mockery of the anti-defection law, and I'm here referring to the Maharashtra case, the response of the judiciary has been too little and too late. It has ensured that a fait accompli ensues, making the remedial steps futile. You will recall that the speaker in the Maharashtra Assembly was supposed to decide those complaints under the anti-defection law, and he still not completed his task despite 2 nudges by the Supreme Court. The capacity of the present judiciary to act as a counter-majority institution seems a remote possibility, not just because of the prevalent political environment, but more worryingly because the judges themselves do not subscribe to the view that the Constitution expects them to perform that function. This is reflected in the recent interviews some of the judges have given in the print and former judges of the Supreme Court have given in the print and electronic media. Even in the realm of appointments to the High Court and Supreme Court, and here I would include transfers, appointments of Chief Justices, all of that, an area in which the judiciary guarded itself zealously, the ground seemed to have been ceded to the executive. Protests from the bench by one particular bench in the Supreme Court sounds more like whimpers and not threats of corrective action. It is this very judiciary which 10 years ago believed that courts are not mere mechanical law-applying conveyor belts, and that judiciary should have a more effective role in issues of governance, now is backing off when these moves are challenged. Although many think that majority rule is essential to democracy, enabling citizens to influence the law through courts can give citizens important opportunity for participation in government. It can do so both by giving citizens the opportunity to influence the law directly as parties to cases, and by enriching the potential effectiveness of using rights to political speech. What populists would like us to do, and what they want to do, using the rule of law, is to close down political competition for the future, and via a claim to a definitive monistic value embedded in a unitary people. Because populism is anti-plural, it is incompatible with democracy. Today we hear people occupying high constitutional posts, questioning the basic structure of the Constitution, calling for limiting the powers of judicial review. In fact, the chairman of the Rajya Sabha is on record saying that how can courts strike down laws passed by Parliament, wresting back the control of appointment processes, and defying or decrying unfavorable judicial verdicts sound very much like the populists who are in denial that democracy is about future political competition as well as present popular participation. The present-day populists, while perennially singing praises of a popular leader, would be happy to use the rule of law and the independent judiciary to shut out public contestation. Thus, we have the spectacle of the political opposition being ousted from Parliament in large numbers, even while important bills are passed in unseemly haste. When this is combined, and this is very important for us to note, and this is what makes it different from the earlier regimes, when this is combined with the growth of oligopolies in the business arena, control of public resources, and in particular media being in the hands of a favored few loyal business houses, a worrying picture emerges that does not augur well for a democracy. You will remember during the UPA regime, the use of electronic media and the debates one used to have on the cases that were pending in the Supreme Court, all that seems to have disappeared. Today's electronic media rarely carries anything which can be remotely suggested to be negative of the functioning of the government. There is a puzzling display of insecurity by the gestures of peaceful protests, not just against the establishment, but against those favored by it, whether in public spaces or even in the virtual space. This explains the intense criminalization of all forms of protests, including the non-violent ones, the weaponization of the law to target political opponents with raids by the ED, CBI, and the tax department. There is a general atmosphere of fear and anxiety, not just among minorities, but those whose politics will not accept this form of populism as the new normal. You could be next in line, targeted for what you wear, what you eat, what you think, what you believe in, or what you speak. Now, all this sounds very negative and depressing to most of you in the audience. They say, yeah, we knew all this, we didn't come all the way here to hear Justice Murali that repeat all this to us again and again. The hope then is cultivating an abiding faith in the Constitution and in constitutionalism, which is understood as the practice of entrenching laws against ordinary legal change, which limits democracy in a certain extent, but is necessary for bringing about a protection of constitutional values and constitutional rights. There are many expectations of our judiciary that the people still have, that it can help halt or at least somehow slow down the populist-led erosion of democracy, that it will protect the weak against the strong, that it will stand against executive attempts at undermining judicial autonomy and supremacy, that it will remind every now and then the present populist regime that it is answerable to the people and the Constitution. For this, courts need to be empowered to review and assess legislative and constitutional changes. Constitutional review of political processes can be compatible with and supportive of democracy, and it should operate in a restrained manner, seeking to protect, not perfect, democracy. As a lawyer myself, and I'm now happy having returned to the bar, as a lawyer myself, I worry that the present day younger generation of professionals do not have sufficient role models to emulate when it comes to standing up to a strong and a repressive regime. Inasmuch as the bar is a microcosm of society, dominated at different times with the prevailing political flavor, we should not be surprised if the office bearers of the Bar Council of India or even the bar associations come across as apologists for the ruling establishment or the judiciary that largely endorses those views. What, however, should concern us as lawyers is when the space within courts become increasingly anti-democratic, when certain kinds of cases will not be allowed to progress in a fair manner, will be listed before certain kinds of judges and not before certain others, when lawyers' bodies resolve that none of their members will represent certain types of litigants or accused. These are all worrying trends. If lawyers don't believe in democratic values, they cannot espouse democratic values, they cannot use the constitution to advance democratic values and bring about the change that we want to see. The inability to conduct a civil debate within court premises must make us introspect about the kind of future we are laying out for the next generation of lawyers. History teaches us that what is happening on the political front is not for the first time, which is why I refer to Nazi Germany, I refer to Chile, I refer to our own political history. Even as we speak, we are aware that elsewhere in this country and definitely in the world, the situation in relative terms is perhaps far worse. A resilient human spirit always emerges to meet these challenges, and we must draw on these inspiring role models of the past to find our inner strengths to take on the present day challenges. Here I must remind ourselves that a mere regime change might not bring about fundamental changes to the manner in which the executive seeks to control the judiciary. Old habits die hard. So where we may heave a sigh of relief when a new regime takes over from the existing one, we should constantly remind ourselves what history teaches us, that having tasted blood, one organ of the state which comes back with a mandate will try and control the other organs. And judiciary is up for grabs when it comes to that. There are, of course, newer challenges before us which the earlier generations did not face. I am referring to the manipulation of our bodies and minds through the internet and the social media, which too have become powerful tools in the hands of authoritarian regimes. This, combined with the complete control of the media through a combination of powerful and loyal business houses and a set of repressive laws, is bound to shrink the available spaces for independent rational thinking and expressing dissent. I was asked, just as I was waiting to address all of you, what the present day lawyers should be doing to meet these challenges. And one suggestion I gave is, first of all, forming study circles and study groups. I am very happy that the modern jurist, this recent issue, has published a critique of the 3 criminal law bills that have now come to be assented to by the President and will be notified and hopefully not operationalized from what we read in the press for another 4 months. But we need critical analysis of the new laws that emerge. While these 3 bills were being passed, rushed through in Parliament, there was other important amendment that happened, which was to the Telegraph Act, which is going to have far-reaching ramifications for all of us. Laws which are tabled as bills in Parliament need to be analyzed thoroughly. And don't wait for the Bar Council of India or Bar Council of State or for a seminar to be organized for this purpose. Form your own study circles. Within the Bar Association, there may be somebody who is very familiar with cyber laws, somebody familiar with criminal laws, somebody familiar with intellectual property rights law. Form your own study circles, prepare discussion notes, bring out what are called position papers. This happens in the American Bar Association. No bill which is tabled in the American Congress escapes the scrutiny of the American Bar Association. We need that kind of a response from our younger generation of lawyers, because things are happening at a rapid pace. These challenges, I wanted to say this one very more important thing. We need to reinvent the image of the lawyer as a friend of the people who believes in peace and harmony in society, rather than as a parasite who sees every client as a potential case. These challenges should be viewed as opportunities for sharpening our forensic skills, our analytical abilities, our collective capacities to share and imbibe best practices from all around the world, from those who have faced and are facing similar challenges. Time is as much a healer as a teacher. The testing of our strengths lies in the trying itself and not getting deterred by our seeming failures. Every failed attempt teaches us to persevere, to remain strong, and to renew our faith in the Constitution, which should guide our actions. This will require imbibing the constitutional values. And I was asked which are the values I would put in the order, in the lexical order. I would consider fraternity as the highest value which a bar association should practice. No member of a bar association should get discriminated because of a different gender, of a different sexual orientation, of a different community, of a different caste. We need to eliminate all these evils from bar associations. As lawyers, if we do not imbibe constitutional values in our personal domain, we are unfit to espouse these causes in the public domain. And the court is a public space. Your arguments will not carry conviction unless you yourself believe in constitutional values. We must protect the Constitution, espouse its values, practice its values, and form our own groups where we take law to the people. We reach out to the people, we make them understand that we are here to advance their cause and not only argue their cases in court. We need to perform a greater public role and reinvent our image as lawyers. Unless we stand strong, unless we stand united, we cannot take on repressive regimes. They will come and go. Politicians change their color like chameleons. And today's friends are tomorrow's enemies and day after's friends again. But as lawyers, we must stand by the Constitution. We must espouse its values. And that is the message I wish to give this august body. Thank you and Jai Hind.
Thank you, Justice Dr. S. Muralidhar. The vote of thanks will be given by Arindam Bhattacharya, the Secretary of the Reception Committee.
We sincerely thank Justice Dr. S. Muralidhar democracy. His profound insights and eloquence have left a lasting impact on us. We appreciate his dedication to upholding the rule of law and ensuring the justice for all. His presence has enriched our understanding of the crucial role played by the judiciary in preserving democracy. Thank you, sir, for sharing your valuable time and expertise with us. Thanks.